everyone. Happy Aloha Friday. Skylar here as always with Chad. And today we have a very special guest, a estate planning attorney from San Diego, Miss Elizabeth Blust. Welcome, Elizabeth.
Thank you. Thanks for inviting me.
So really quickly, I think a lot of people have this kind of, this idea that estate planning is a really complicated, cumbersome, and expensive process. And, can you kind of just talk about the not having an estate plan, a trust, that kind of thing, the process of probate, what that means, and just kind of dive into a little bit more information on that.
Sure, I'd be happy to. Again, I'm Elizabeth Blust, estate planning attorney in San Diego. It's funny, I'm dealing with a case right now where a guy died and his wife said he didn't believe in wills. And as a result of his not believing in having a will, his nephew that is now like 40 that he only saw once when the kid was a baby might end up with half of one of his properties in California. Because the statutes don't care if you believe in wills or not, there are rules. And one of the things, even if you have a will only or nothing and not a trust, you still have to go through probate even with a will. And people always hear, oh, what's so bad about probate? Or, probate's terrible. Well, why would you want to avoid probate? It's long, it's expensive, it's public. There's lots of reasons, even if you have documents in place that have to be probated, it might not be something that you want. The fees are set by statute. I mean, you can hope that maybe your attorney or your executor might waive the fees so that your heirs get more, but I'm not likely to waive my fees if the statutes of California say that I'm going to get, it's kind of a sliding scale thing. But, if I stand to get, say, the default on a $500,000 estate, that could easily just be your property and not even anything else in San Diego County. The statutory fee for me would be $13,000. The statutory fee for the executor would be $13,000. So right off the top, just at kind of your basic estate with one piece of property in it, you're looking at $26,000 just in fees. So when you look at an estate plan while you're still alive involving a trust, and maybe you're looking at it thinking you might have to spend $2,000, $3,000, $4,000, $5,000 on that, remember that if you don't, then just your one piece of property is going to cost you $26,000 in fees after you die. So suddenly that $3,000 or $4,000 on a trust doesn't seem like such a bad investment.
Totally.
You actually answered my question right then. Which I was going to ask you about, what it takes to go, what happens when people go through probate when they don't have a trust in place or a will in place. And you sort of answered it before I was even able to ask it, but I've seen, it was perfect. So, as an agent and a realtor, I've seen a lot of people that, including, my own uncle didn't have a couple properties in a trust. He didn't have a will. It had to go through probate. My dad there was a trust, but it wasn't set up to where these certain properties that he wasn't really doing anything with were part of that trust. So even if people do have a trust, sometimes they don't take the extra step to make the property part of the trust. In this case, it had to go through probate. It took like 2 or 3 months. My dad was the executor on the trust, so he was able to handle everything, luckily, but it doesn't always end up that way. You know what I mean?
Yeah, my favorite thing is when we sit down to sign the final documents and everything, and despite my best efforts to get all the information from the client ahead of time, inevitably there'll be somebody who says, oh, what about my timeshare? So don't forget your timeshares when you're preparing your documents.
Yes.
They're usually not valued high enough to have to go through full probate, but there's still going to be some paperwork involved to transfer that interest to a living person after you die if you don't have it in there.
I never thought of a timeshare as part of that. That never even crossed my mind. I'm like, okay, that makes sense.
Makes sense. That's an asset, right?
Because essentially what probate does, part of it is making sure if you have a will or if you don't have a will and it's just passing based on the laws of the state, that the property gets to the right people. And typically that's going to be your spouse if you're married, your kids if you have them, If there's no spouse or kids, then it might be to your parents. If they've died, then your siblings. If they've all died, then your nieces and nephews, that kind of thing. So obviously, if you don't get along with your kids, you can't just hope that they don't find out that you died. It's better to actually put something in your plan. You either skip them and go straight to your grandkids, or pick somebody else that you love more, or go to a charity. You know, there's lots of reasons to do that. What happens with probate, and this is where a trust can be useful to not have probate, is if you die and you were the owner of something, your signature was required to transfer title to somebody else. So if you're dead, who's going to sign that? Nobody has. A power of attorney expires on your death. So people always call and they say, well, I had power of attorney. I'm like, too bad, they've died. So that power of attorney ceases to be effective now. There's a few things under a healthcare power of attorney, like autopsy and burial, that do continue after death, because that's the nature of a healthcare power of attorney. But for your financial affairs and that kind of thing, that stopped at death. So the role of the court in that scenario is to appoint somebody, the executor or the administrator, that has signature power, that can legally enter into a contract for sale, or can legally sign the deed to the kids, or whoever's going to get it. So even if you have a will that says who it's going to, unless there's a living person that has the authority to sign on the dotted line, then you're going to end up with probate at a certain dollar amount. So as of the beginning of this year, 2020, the threshold in California is $166,250. So if you're combined, so say you have a bank account and a mobile home and a bunch of different things, and they add up to more than $166,250, then you're going to have to do some kind of probate procedure. If it's less than that, then there are some different things depending on if it's real property, or just maybe you have one bank account. I have a situation now where a lady had one bank account that had like $30,000 in it, and she didn't have a pay on death beneficiary. So we don't have to go through a full probate just for that $30,000. There's some smaller procedures, but there's different thresholds even under that primary limit, that if it's real property, you still are going to need the court's authority somewhere along the line to take that court document down to the county recorder's office where the deeds are recorded, so that they know that you had the authority to make that transfer. So lots of little pieces. And am I saying too much? Is it good? But having a trust, there's already people in place with signature authority. So when you die, that next person, almost like having a company, and you're the CEO now, and then when you die, hopefully the company doesn't go out of business. There's rules and regulations in place for that company that somebody else on the board of directors or the vice president or whatever takes over the company. Trust operates similar to that. So you die, there's already somebody with signature authority in place that steps into that role, and you don't have to have the court's approval. So that's where the trust is.
Do you see a lot of younger, sorry, Scott, I just have one quick question on that. A lot of first-time home buyers, I think, people that I deal with a lot, don't tend to have a will or trust in place because they're young, they're in their 30s, they're in their 40s. And I think you probably would agree that most younger people don't get to that point to where they do form an entity like a trust. I mean, would you, as doing what you do and seeing all sides of it, I think, would it be safe to say you would advise anybody that owns real property or has any sort of assets to form an entity like a trust pretty quickly thereafter purchasing real property?
Usually, yes. With a married couple, there's a little bit of protection in California because of community property, or maybe they took title as joint tenants, that it's going to go to the survivor. But if you are not married and you own property either by yourself or with other people, then it's a good idea to have a trust if it's by yourself, and then some kind of structure if you own it with other people, that it goes to, somebody, say you and two other people buy a property together. Ideally, maybe you'd have a company, an LLC or something set up to own that property, and that would help direct where it goes. But otherwise, at least have something in, even if it's a simple will that you hand wrote at your kitchen table of, everything goes to my brother except my interest in this piece of property goes to the other two people.
Right.
Interesting.
Yeah. Okay.
Hey, so I got a question for you, Elizabeth. When it comes to like the timing that probate, probate takes a while, and
Yeah.
from my experience, it varies based on the complexity of, you know, the what the judge has to, or what the court system has to kind of, you know, divvy up, so to speak. Can you kind of give like an idea of, from start to finish, how that process looks timing wise? Is it like a general kind of,
Sure.
like, there's this kind of like the timing, how does that work?
Yeah, so there's some parts of the probate process that are built into the code that even if there's, you know, no line at the door, so to speak, you're still going to have to wait 4 months for like creditors to have an opportunity to file creditors' claims against the estate, and some things like that. That being said, there usually is kind of a line at the door. So even if within a couple days after somebody's death, you get everything signed that you need for the petition for probate, there's a notice period of publishing in the newspaper, so that, again, with the creditor's claims, that anybody who feels they may have an interest, either as an heir or as a creditor, has an opportunity to be aware of the hearing and, you know, go to the court and insert themselves into the process so that they can make sure they get notices and that kind of thing. So there's going to be a mandatory waiting period for that hearing. And off the top of my head, I can't remember. I think it's 30 days, but it might be 15. I can't remember. So anyway, you've got built-in waiting periods like that for things, 4 months for the creditor's claim. But it's not like the court doesn't already have a whole bunch of people who are already in probate ahead of you. So in San Diego County, there's 3 probate judges. They try to get the opening petition for probate on the calendar as fast as they can, just so they can get things going. But even so, it usually takes 2 or 3 months to get that hearing date. If there's an emergency, say I had this happen once where the house was already in foreclosure before the person died. The notice of default had already been filed. So in that case, there are some ways to go into the court and say, you know, we need some kind of authority to act quickly to, you know, get the house on the market, talk to the mortgage company, prevent the sale, to protect that asset for the other creditors and hopefully for the heirs, the beneficiaries. So that can work. But say you get on your hearing, your hearing gets scheduled, say 2 months after you file the paperwork. You publish a notice in the newspaper, you show up at the hearing. If nobody objects, then the judge says, okay, you are officially the representative for this estate. And then you can apply for a tax ID number for the estate if the executor. Start sending out those notices, let the tax agencies know that a taxpayer has died. Let Medi-Cal know that possibly a recipient of Medi-Cal benefits has died. That's partially to prevent fraud and partially to let them know that if they have assets to recover from the estate, that now's the time. And then once that 4 months runs from the creditor's claims, if the creditors have made claims through the probate process, say that the claims, the debts outweigh the assets of the estate, then there's a process in the statutes of who gets paid first. You know, mortgage and taxes have a higher priority than your credit card debt, that kind of thing. And once everything gets all wrapped up, usually the executor will file an accounting with the court. If all the beneficiaries or heirs agree that, oh, we don't really need an accounting, then there are circumstances where it can be waived. I haven't found in my experience that it saves much time. I like to do the accounting anyway, and then everybody's on the same page. They can see the money going in and out of the estate. And then they file that accounting with a petition to distribute. And that, again, they try to get those on the calendar. I just filed one last week. It got on the calendar for September. So even though we're all done, we're ready to close and give all the heirs their checks, it's still not going to happen until like the end of September. So that's kind of the timeline of the quickest probate possible, you know, would still be, you know, 6 to 8 months. I've never really had one shorter than a year.
In other words, set up a trust.
Yeah. And I mean, not that there can't be complications with the trust. And some trusts are designed to last a long time with periodic payments, especially if there's minors. You know, if you have people under 18 that are receiving payments, you know, you might want the trust to last a long time. And otherwise, if you're just like, everybody's an adult, I don't feel any need to control this money beyond the grave for them. Trustee, settle my debts, write everybody a check, close it out. It can happen. I've seen that. I've had a few trusts that were done in 3 months, and that includes transferring property.
And that actually leads into my next question. And my next question was types of trusts, because from a real estate perspective, I always ask the question, because there's additional paperwork, do you hold the property in a trust if you're selling, obviously, or even if they're buying, are you buying in a trust? Because it creates a little bit of additional paperwork, but more importantly, I've seen different types of trusts that are able to do certain things that other trusts are not able to do. There's a living trust, there's a family trust, you could just do, the Skylar Stokes trust. Then there's irrevocable and revocable trusts. So do you have kind of a Cliff's Notes version of what people would, I guess, it's probably pretty deep and complicated, but I don't know if there's a,
it is. I can give you the quick version. Yeah. So basically, it has to do with who has control over the asset. So if I have a house, if I have a house and I put it in a revocable living trust, then I still have all the control over what happens to that house. I can decide who lives there, whether to keep it, sell it, have tenants, roommates, whether to put a lock on the door or not. It's mine for all intents and purposes. It's just I happen to be holding it in my living trust, my revocable living trust. If I, for whatever reason, and we can get into that a little bit, want to put my assets into an irrevocable trust, I will no longer have control over those assets. Now, the typical reason people will do that is to be able to qualify for some kind of public benefit that is based on how much money they have. There's some other reasons, but that's usually the most common that you see. Like, I want to qualify for some government program, but I have too much money, so I need to give it away. And I don't actually do irrevocable trusts because they're much more complicated. There's timelines. Like if you give everything away today into your irrevocable trust and then apply for the benefits tomorrow, they're going to say, well, obviously you only did this yesterday, and there's different look back periods and that kind of thing. But with an irrevocable trust, if I put my house in there and somebody else is the trustee, I can't technically make them do anything based on my personal opinions anymore, but I'm still the beneficiary of that trust. They're still supposed to be making the decisions in my best interest, if that's the way the trust was set up. Now, there's other reasons that you might set them up and maybe somebody else is the beneficiary. But that's kind of the main, high level difference, is that most people with a revocable living trust, it's a property management tool and a probate avoidance tool, maybe a little bit of a estate tax avoidance tool, although the federal estate tax limit has been raised to 11.6 million and is now tied to inflation, at least for the foreseeable future. So California does not currently have its own estate tax. So that's not as much of an issue as it used to be. When I first started in this business about 10 years ago, the threshold was 1 million for a single decedent. If you died with more than $1 million, you could owe federal estate tax. So that used to be a big reason for people even of a modest estate to do a trust. And I think that's where a lot of people still get that idea, like, I need to be a millionaire. Well, only a short time ago, just having 2 pieces of property in California, you were a millionaire just there, never mind any other investments or anything that you might have. So a living trust that is revocable is typically for probate avoidance and just kind of to be quick and private after people die. Whereas an irrevocable trust is usually more for some kind of public benefit program and qualifying for some income-based or asset-based benefit that you need to liquidate, but you still want to be able to have the benefit of those things even if you don't have the control.
I think there's 2 points here that I want to make. One is, I think in the foreseeable future, I would imagine the state might consider opening up that that estate tax again, just because of where we're at financially as a state. So something to think about. Number two, you mentioned something earlier, and Chad was talking about it, about kids. And something that I think a lot of people don't necessarily think of is, you know, like, oh yeah, my kids are going to go to my brother-in-law, or they're going to go to my sister, or whatever it is, right? Unless you have directives in a trust or in some sort of, you know, legal document kind of outlining where they're going to go, who they're going to be, you know, who's going to be their legal guardian and all that kind of stuff. The court can also decide, you know, basically who would be the person that's going to take care of them. Can you talk more about that? Because I think that's a huge thing that a lot of people don't know, and it can be a really big problem.
Yeah, Skylar, I'm glad you brought that up. That's actually one of the aspects of estate planning that first caught my attention when I was still in law school, that made me think about this area as a career. I had a friend, one of my kids' teachers, I think it was, whose sister had died. She and her sister did not get along, hadn't spoken for years, and the sister had children. And their father, the husband, they're still married, was still alive. But after the wife died, he was so distraught, and it was an unexpected type of death, and he just didn't have the wherewithal to cope with his wife's death and raise their children. And so one of the neighbors called the Child Protective Agency, and they said, oh, who else, you know, until the dad can kind of get back on his feet or whatever, is there anybody else who can take care of the kids? And the sister, the one that I knew, didn't see anybody else. She was kind of keeping an eye on things from a distance, didn't see anybody else stepping up, except, you know, these children would have ended up in foster care. And I've heard really good stories about foster care, and I've heard some really bad experiences with foster care. So she stepped in and took in her niece and nephew into her home, and things ended up okay. But she knew that her sister would not want her to have, like, they did not get along. You know, she did it out of a sense of obligation, and this was blood, but she knew her sister wouldn't have picked her. Her sister would have picked, like, any number of other people besides her, but none of those people thought about it or were aware or knew to step up. Whereas if you have a guardian nomination, and the easiest place to do that is in a will, but you can also do it in a standalone document, you can nominate. And the default under the law would be the children's natural other parents. But say in a divorce situation where you're like, I know the court's going to look at the other parent first, but, you know, there's a reason I divorced that person. You can nominate somebody else. Now, the court will still most likely look at the natural parent first, but if 5 people are coming forward talking against that other parent, and you've got a document that you left before you died that says you don't really want that other parent having sole custody, then the court is definitely going to, you know, take that into consideration. And even if, you know, say something happens to both parents, maybe you got along great, you both would have been great parents individually, like the case with the friend of mine. The other parent was alive and normally really great guy, loved his kids, but just his grief was too great.
Yeah, just couldn't.
So in that case, it would have been great to have a list say, and if he can't do it, whether permanently or on a temporary basis, then here's these other people, and maybe they're not relatives. Or maybe there's 5 really great people all stepping forward, and you've got one of them in your list that you left in a guardian nomination before you died. That can sway the court. Like, of these 5 people are all like, oh, pick me. I'd be a great parent for these children. They can say, oh, well, Elizabeth put so-and-so down, so you're all great, but we're going to go with this one because that's who she picked.
Interesting. Yeah. I have a kind of off this topic, but this is in your world, Skylar. As far as people's personal investments outside of real property, you know, stocks, bonds, retirement accounts, if your grandfather dies, for example, and he owns a bunch of stock in Tesla and Amazon, let's just say, which would be awesome. But are those funds and those investments and assets subject to the same sort of of rules as real property in a trust, or are those, are those, the ownership of those held differently, or how does that all work? Because I genuinely don't know.
The retirement accounts, the way the retirement accounts are set up, generally they're going to ask you for, a beneficiary from, whoever you want to pass your assets off to. But there's rules at which you have to, basically take the money out because you've deferred all this money for so long. And they're basically saying, okay, you basically have, or the decedent has had tax deferral, they wrote it off on their taxes, and it's grown to this amount. Well, now, Uncle Sam, we want a piece of that because that's just kind of what, we agreed to. And so there's rules on which you have to follow in order to like take the money out in the retirement accounts. But when it comes to the individual accounts and brokerage accounts and all those other sorts of things, bank accounts, to Elizabeth's point, it is very much based off of just divvying up in the way that the trust says, or the way that if you have to go through probate, what the judge says or what the court system says. So don't do that.
So some accounts can just have a pay on death beneficiary. So they don't have any rights to the account during your lifetime, but when you die, it would go to them. And a simple bank account, usually you can have 10 people in there, but they're each getting a tenth. You can have 4 people, they're each getting 25%. The bank, just on a regular account, won't do 10% to this guy and 30% to this guy and do it that way. But they'll do even shares to multiple people. But that's still kind of a pain because then they still have to get a signature from 10 different people. But if you don't have huge assets and you just have that one bank account, then that could be the way to go. A lot of the more like investment type accounts, I don't know if they have that kind of flexibility with the beneficiary designation. I see most people putting their larger investment accounts in their trust than they have.
Elizabeth, another question for you. How long does it take to, like, from start to finish, set up a trust, will, and then power of attorney? How do those two things on the bottom there work?
Okay, so the trust would control whatever assets you put into the trust. So usually at a minimum, the real property goes into the trust. A lot of people, like I was saying, will put their larger financial instruments in the trust. Typically, we don't put automobiles or vehicles that are registered with the DMV. So that's certain boats and mobile homes are considered non-probate assets. So they don't have to go in the trust. Some people will, but they usually don't. Most people leave their small, regular, day-to-day checking and savings account outside the trust, and they just have a beneficiary designation on them. But anything that's not in the trust would be controlled by the will. So I will usually do the trust and the will together on the same day, and so they all have matching language. Usually we do what you may have heard the phrase a pour over will. So usually we'll do whatever wasn't already in the trust before the person's death. The will say, leave everything else to the trust. And that way, whoever, and usually the executor and the trustee will be the same person. So whoever's in that role doesn't have to worry too much about which hat they're wearing at a particular time. Is it my executor hat or is it my trustee hat? It may make a difference which account they write the checks out from, but in the long run, the gifting usually is going to take place from the trust. Years ago, it was more customary to see that the tangible personal property, the sofa, the jewelry, that kind of thing, didn't usually get put in the trust. And we would have those kinds of gifts in the will, and then the bigger things in the trust. But for the past, I'd say about 15, 20 years, the trend has been just put all of it in the trust, and then you just know that everything is in the trust. And we'll see, as people die that did it that way, if that turned out to be better, or no, maybe we'll go back the old way. It's probably too soon to tell, but I think from the administrative point of view, the successor trustee kind of likes not having to worry about, wait, was this under the will or was this under the trust? But it is still a good idea to have both of those. And then, Skylar, as we were talking about earlier, if you have minor children and the guardian needs to be nominated, that would be in the will as well. And then a power of attorney is, we mentioned way back in the beginning, if you still remember, that a power of attorney ends when you die. So a power of attorney would be for anything during your lifetime that is not part of the trust. So that would be things like insurance, government benefits. If you paying your taxes every year, say, you know, you're getting older, or maybe you travel a lot. You could be young and healthy and you just travel a lot and you want somebody else to be responsible for handling some of these things on your behalf. The idea with the power of attorney is that you are the principal and you are delegating tasks to your agents who will take direction from you and do things as you tell them to do. You will hear the word durable power of attorney. In a traditional non-durable power of attorney, once you become incapacitated, so either you're too sick, you get conked on the head, whatever, you're still alive, but you can no longer direct your agent to do what you want them to do, then the power of attorney ended. That was a traditional power of attorney. And then as it became more a part of estate planning, we realized if we make it durable, it endures into your incapacity. So now it will say, even if I'm unable to direct my agents anymore, I still want them to do the same kinds of things I told them to do before, and I trust them that even though I am no longer able to guide them day to day, that they will do that. The biggest difference there is that absent an agreement with your agent that they will pay your taxes, do things for you, whatever, they have the authority, but not the obligation. So the biggest difference in that respect between having things in a trust that your successor trustee will take over when you're incapacitated, that is their duty and obligation. And if they have accepted the task of being a successor trustee and they let your property fall into ruin and they don't pay your taxes, they can definitely be held accountable. There's not as high a threshold of obligation under just a power of attorney, but it's still a very useful document. I definitely have all my clients have it.
So also too, to kind of, I guess, speak more about that, when someone becomes incapacitated to where like they cognitively have issues, they can't function properly, or let's just say they get super hurt and they're not making decisions that they normally would make, a power of attorney would be something that could help the person who is most trusted, I guess, direct the healthcare for that person, you know, as until such time either they got better or, you know, they passed away.
Right. Yeah. With the healthcare power of attorney, definitely. As long as you are able to make your own decisions, even if it's blink once for yes, blink twice for no, the doctors, and if your answers make sense, like, you know, you're not talking about elephants in the room or something, but your medical care, then they should be asking you and getting your answers and doing the care that in the moment you are saying you want or don't want. But yeah, with the healthcare power of attorney, if you clearly aren't making sense or you're in a coma or whatever, then the doctors know that you have picked somebody in advance who hopefully you've had a discussion with about your care. And in an advanced health directive in California, advanced healthcare directive in California, there will usually be both your healthcare desires and an appointment of an agent. Years ago, when they were done in two separate documents, these days you're more likely to see, and people call it a living will, but these days it's usually more of a combined document. You don't have to have the agent. You can just have a healthcare directive that says, you know, I don't want to be on machines, or do everything you can to save me at all costs. I want to donate organs. I don't want to donate it. You can have it all laid out there, even if you don't have a person that you've appointed to guide the doctors through that document. Some people just have the agent, and they know their agent well enough. They let them make all the decisions as to organ donation and all that kind of thing. Most people have an agent, and they have a plan, and they talk to their agent, so it all kind of works together.
Awesome. Good deal.
But that's the key thing. You have to have it in advance before you hit your head on the nightstand. Yeah.
Right. Totally.
Get it done sooner versus later, it sounds like.
Yeah. Cool. Well, you know, I think that kind of wraps up the time for today. Chad, do you have any more questions?
No, I think we touched on everything that I kind of had questions on, and I think it helps people that, do listen to this, every week kind of understand the importance of putting your assets in trust and calling someone like Elizabeth if you do have questions or you want to get something in place moving forward. Even if you're in your 30s or your 40s, I think it's still just as important to have if you do have, real property or anything like that. So yeah, I think this was super helpful. I appreciate you coming on today.
Elizabeth, how can people get in touch with you? Where can they find you?
Oh, my website is mycaliforniaestatelawyer.com, or you can call me at 619-607-0235.
Awesome. Thanks again.
Thanks, Elizabeth.
Thanks, Chad. Thanks, Skylar.
Have a good weekend. Aloha.
Happy Aloha Friday.
All righty.
Have a great weekend.
Aloha.
Bye.
Bye.